the family business as a subject, we'll tackle about the family business succession planning. Okay, so there. Um, the next generation family members may be reluctant and unprepared or unable to lead. So these are the issues that are actually coming in the succession of a family business. Now, the family members and other shareholders may not support the choice of successor and leadership, but the business may not have enough liquidity to support the transition of ownership within the family even. Okay? Now, uh, the context of the chapter discussion will suggest that many succession problems can be avoided or mitigated if the family business plan for succession is being held uh, regularly, or anticipating that the succession will happen eventually. Now, rather than wait until the last minute, when options may be more limited at the time. Now, regardless of when a business thinks a changing of the guard will take place, and the conclusion may be made later on, it is important to always have a plan that is ready for that eventuality, since the unforeseen circumstances can cause a sudden need for the new leadership. Who knows? Things happen differently and unexpectedly. Now, there is a survey that came along from the PwC survey that resulted, and its author's conclusion will ring true for the stakeholders to experience working with the family members with the family business. Now, the chronic failure of the family businesses to engage in formal succession planning is at odds with their tendency to focus on performance, uh, long-term performance better than businesses that are not family-owned, actually. Okay, so there's a context in the Harvard 2012 Business Week Business Review article, "What You Can Learn from Family Business." Stipulates that by author Kachner, and assert that executives of the family businesses often invest with a 10 or 20 year horizon, concentrating on what they can do now to benefit the next generation. So that is the context of what you can learn from the family business. Now, these family businesses, however, often have no real plan for how the next generation will realize those benefits as successor, owners, and as leader. Okay? Now, to be fair, um, one reason why so many family businesses do not engage in proper succession planning is that it is difficult and complex. Okay? Family business succession planning must take account of countless unknown future circumstances and current facts that are continuously changing and interacting, including business factors like the economy, the regulatory environment, and the state of the market in which the business operates. It's important. Now, as well as the family factors even, or like family dynamics, and the changing skills, the maturity that goes along, and the career objectives of the members, the economic needs of each of the members of the family, the health status even of the individual family members are also to be included in the loop. Now, under these circumstances uh, of pervasive uncertainty and complexity, it is understandably difficult for the family business owners to comprehend how they could construct a proper business succession plan. However, if the stakeholders and the decision makers could provide them with an organized, local, logical, step-by-step outline for the succession planning, they may be, yeah, much more likely to begin with the process and eventually develop a kind of robust, written succession plan that can be provided in the succession activity of the business, family business. Okay. Now, the blueprint for the family business succession planning will be articulated. No. Okay. The section, okay, the family outline for the family business and succession planning will be articulated in our discussion. Now, the section on each project includes commentary event that provides the description of the explanation of the legal concepts of the succession planning. Okay, and one how are we going to be articulating this? So the stakeholders should also ensure that the parties and the legal context of the agreements is necessarily secured, and this document does not represent or understand uh, any predicaments in terms of legal disputes and legal questions about the matters on how to resolve the succession planning. And then, okay, so there. So what are needed for the succession planning to come along? So one is collecting the proper information. So collecting information. Now, before the consultation begins, the family succession plan, the stakeholders included are the councils, the legal councils, should review the copies of current business governing documents that is related to the party contracts, the state planning documents that might affect the governance, the ownership, and the succession of the business. The lawyers and the legal experts of the corporation should also help the clients and other to document this properly. And then this process also offers the clients an opportunity to get their personal and business records that is organized and established procedures for keeping them organized and current. So these are the participation of the attorneys and the legal expert that is part of the consultation process of the business planning procedure. Okay, so there. Next is after the collection of the information is the valuation. Now, the proper business succession planning will require a reliable valuation. Valuation in terms of the stock of the family's primary business entities and other important business assets when planning commences and throughout the term of the family ownership even is going to be articulated. Now, if the client do not already have current opinions of value, okay, counsel should help the clients obtain them. So that's the very essence of why the attorneys and the counsel should be consulted properly as family members as the client. Now, this can also help the attorneys and the clients avoid major mistakes in the planning process that the attorney might otherwise make it working on faulty assumptions of value. So there. And then obtaining the current valuation can help the clients in other ways as well. No? So what are these? The valuation process can reveal information about the strength and the weaknesses of the client's business. And that is important. And that the clients can use to improve the operations and the profitability of the business. And the valuation professional can also help counsel draft the most appropriate purchase price language in the client's buy-lease agreement or buy and sell agreement. And finally, the clients can maintain the relationships with the valuation professional to obtain updated opinions on a regular basis even. Okay, for the purpose of the client's buy-sell agreements and for the transfer of ownership, for the transfer of interest within the family to implement in the succession plan. Okay, so that is number 2, no? So number 1, again, if I may repeat, is collecting information, and then business, and then the valuation is number 2, and then number 3, the business continuation plan. Okay. The business continuation plan. Okay, if there are key family members who are particularly important to the operations or success of the family business, then early in the succession planning process, counsel should help the client establish the mechanisms to address the disruptions that would incur or caused by the sudden death of or incapacity of one of the key family members. For example, the attorney should ensure the controlling owner has updated powers of attorney, appointing an appropriate person to vote client's interest if suddenly rendered incompetent. Now, the attorney should ensure that coordinating counsels or controlling owners stock designates an appropriate transfer on death beneficiary, okay, such as their living trust, to avoid the delay of the appropriate transfer on death on the probate if they die during the succession of the planning process. And the attorney should ensure that clients have a plan to replace the chief executive, okay, at least on an interim basis, if he or she unexpectedly exits the business in whatever forms. And these are temporary measures that will be replaced or supplemented by more permanent structure and procedures when the clients have made more progress on their succession plan. Okay? Now, number 4 is restructuring. Now, what happens? So, after the council reviews the existing business documents and obtain the inputs regarding business valuation, the council should work with the client's accountants to help the clients determine whether the business should be structured or reorganized. It may be that making changes to the legal structure or tax treatment of the components of the client's business will facilitate the succession planning. For example, it may be easier to plan transitions of ownership if the primary source of cash flow is taxed as a partnership rather than a C corporation, or if the legal estate assets are held in entities that are separate from primary operations. Now, the attorney should work with the client's accountants to ensure that any restructuring will be taxed efficiently, including income taxes and transfer taxes. And counsel must take into account other advantages of restructuring, such as the limitations of liability, the operational efficiencies, and the diversifying ownership opportunities for the family members. Now, the attorney should include also the plans for how new ventures will be added to the structure in the future. Okay, so that's number 4. Number 5 is the governance and buy-sell structures. Okay, governance and buy-sell structures. Now, how does it happen? Now, before updating the senior generation owners' estate plans with respect to the allocation of ownership among their beneficiaries, and before the senior generation owners make additional lifetime transfers of ownership interest to members of the junior generation or trust for them, counsel should help the clients design the rules that will regulate governance, ownership, and owner exit after control has transitioned down from the senior generation. Now, this includes 4 topics which can be added up and be addressed in the business's governing documents and the agreements among the owners. Okay, so that's governance and buy-sell structure. Now, next, how do you do that? No, so unit voting is one. So the power to exercise owners' voting rights primarily includes the power to appoint or remove board members and approve or veto major transactions. Now, the client should consider who also have the right to exercise owners' voting rights. Now, in some cases, voting units can be held in trust to be voted by the judiciary or a committee of judiciaries. Or the owners can sign agreements about how they will vote their units or particularly on particular issues. Or governing documents can also be drafted to increase the scope of actions that require owner approval. Okay, that's unit voting. Next is the governing board. Members of the governing board, including acting collectively, usually have the following powers: power to appoint and remove top executives and determine their compensation, power to issue dividends, and power to oversee budgets and long-range business planning, risk management, and strategic planning. Now, the clients must decide how the board will be composed and how board members will be elected. Now, clients should consider the advantages of requiring an independent presence on the board, especially after members of the senior generation exit the business. Now, under most default rules, each board member is elected plurality, but it may be desirable to classify the board so that each substantial owner can have one or two seats on the board. Now, governing documents can also be drafted. It is going to be drafted to increase or decrease the amount of actions on the board that can authorize without approval of the owners. Okay? Next is the executive authority. Now, what happens there? Now, executives and officers have power and responsibility to run the day-to-day business, hire and terminate staff, develop budget and plans for approval by the board, and sign checks and contracts, including the loan agreements, within the limits set by the board, definitely. While senior generation owners are alive and competent, their status as patriarch or matriarch may naturally enable them to help their children and grandchildren make decisions about a lot of things, included the executive authority and the compensation among family members. But after they are gone, the business owners and the board must be a way to make the decision about the appointments, the titles, the duties, the compensation with the family members. That is fair and will not disrupt family harmony. Okay? Next is the beneficial ownership. Okay? Owners of business equity, which can be referred as beneficial owners, can, when considered apart from the power to vote the ownership interest, have the right to receive profits and appreciation from the business operations. Okay? Note, if the owners are also employees, they may receive most of their annual economic return in the form of compensation. Now, the client should consider whether non-employee family member, should own shares and whether shares should be held in trust, primarily to protect them from the estate taxes and claims of creditors in the event of divorce. Okay, so the client should also decide upon mechanism for owner exits that are fair to the existing owners but are not disruptive to the business. Now, the acquisition, the ownership, the transfer of the ownership interest, including redemptions triggered by retirement or other separation from employment of the business, should be drafted into the updated governing documents. So that's important. Now, it should be noted that although the business governing documents can provide the legal rules by which the business is governed and owned, the client. Okay, the client should also consider developing a family constitution based on the mission statement and other policies that will guide decision makers when they apply the legal rules. Now, the business legal documents cannot express the spirit and the philosophy of the family as effectively as the principles that family members write in plain, understandable language, like English, and agree to uphold. Okay, the key contracts. The attorney should help the clients negotiate retirements, or rather, restatements of key contracts with third parties that should or must be updated to be more consistent with business restructuring and anticipated changes of control of ownership. Such contracts include loan facilities and franchise dealership agreements. The extent to which such contracts can be changed may affect the decisions about how or when to implement other elements of the business succession plans. Now, the client should also consider whether written contracts for related party transactions should make the succession plan more effective. Okay, such contract may also include the following. What are these? Now, the leases between the operating business and the family-owned entities that hold real estate or equipment used by the operating business. Okay, the debt instruments for loans from owners or the equipment used by the owners to the businesses rather, or reimbursement, contribution agreements among the business and the owners who have personally guaranteed business debt, and the employment agreements for family members who work for the business. Okay. Next is the update senior generation owners estate plans. Okay. The attorney should update the senior generation owners. The estate planning documents including the wills and the revocable trust, consistent with business restructuring and decisions that the client have made about future governance structures and the ownership rights. Okay, so that's important. An update should address the following: the specific allocation of stock or unit voting rights, the specific allocation of beneficial interest in business equity, the disposition of other important business and personal assets, specific use of life insurance proceeds, the source of funds needed to pay estate taxes, and the structure, the funding, and the amount of charitable bequest. Okay? Next is the plan for senior generation ownership retirement. Plan for senior generation owners retirement. Before the senior generation owners transfer control and substantial equity interest to the junior generation, council should work with the senior generation and their financial advisors to help ensure that senior generation members will have sufficient economic means to support them indefinitely in retirement or in the event of disability in particular. Now, council must seek means to support cash flow and the asset for retirement that are not dependent on the success of the next generation of owners. Although plans like unfunded deferred compensation, private annuities, or seller finance redemptions may look good on paper, but they may place disproportionate risk on members of the senior generation when they are no longer in the position to affect business outcomes. Now, next is the lifetime transfers to the next generation. Ideally, the senior generation owners will be able to oversee the transition of leadership and ownership of the family business to the next generation through lifetime transfers, rather than rely on post-mortem contingency planning. Okay, counsel should work with the client's accountants to design lifetime transfers that are tax efficient, but the attorney should not sacrifice the financial well-being of the senior generation in a blind rush to redistribute wealth to avoid estate taxes. Okay? In most cases, a combination of diverse approach to estate planning, tax planning, can give the clients time to implement a family business succession plan at a pace that makes business sense and is more likely to meet the long-term economic needs of the senior generation owners and their successors. Okay? And that ends my discussion for the day. Thank you.